thank you very much, Professor Abbe Brown and Professor Caroline Kube for being here today. Abbe is Dean for Student Support and Professor of Intellectual Property at the University of Aberdeen. Her research, teaching, and policy engagement explore intellectual property and the intersection with other legal fields in addressing key societal challenges. Abbe, she's the chair of BILITA, that is the British and Irish Law Education and Technology Association, and among other things is an NcCube Constructing a Digital Environment Senior Expert. So thank you, Abbe, for being here today. I'm also going to introduce our discussant, who is Professor Caroline Kube, who is currently head of department of the commercial law. Although I think you're head of department until the end of December, so probably you're looking forward to that. At the University of Cape Town, she is the Sarchi Research Chair in Intellectual Property, Innovation and Development, and again, among other things, she's co-editor of the South African Intellectual Property Law Journal. Today's talk is very much in line with Abbe's approach to intellectual property and understanding, again, interplay with other regimes and kind of the societal dimension to it. So the premise is that technology and data can obviously bring lots of opportunities to kind of tackle societal challenges like environmental sustainability, but often the approach to regulation is often kind of very siloed. It's not very holistic, and it doesn't really engage with technology, with relevant technology and data regimes. So we're gonna learn about her current research, and I'm very excited about it. So thank you both for being here, and obviously also for thank you all the delegates for attending as well. Professor Brown, the floor is yours.
Fantastic. Thank you, Guido. Thank you, Arletta. Thank you, everyone, for inviting me. I think Scotland is just the most fantastic of things. So very honoured to the chance to speak to everyone. Also very delighted that Caroline has kindly agreed to be the discussant, to lead our discussions. It's been a long time since we've seen each other in person, so it's wonderful to get to see you on screen. So Guido, I think, has summarised my presentation probably a lot better than I will. In some ways, it builds very much on what I've been doing for many, many years, but it's also, I think, really trying to take that in a little bit of a new direction. I think it's much more interdisciplinary. It's trying to get away, frankly, from the power of IP law, but as we'll see, I don't quite ever seem to manage to do that. And I think that the power of IP is one of the themes that we'll really be exploring. So a quick overview. I think we're going to assume, although it's absolutely not unquestioned, that technology and IT can contribute to increased societal benefits. And we will also, I think, accept, although often welcome to challenge, that a lot of regimes which focus on wider societal goals, such as, say, health, they often lack a focus on IP and data, and the regimes which focus on that. And I think this can be a real problem. We can have regulatory regimes which clash, underlying values which clash, and different rights which clash. And this, I think, can be a risk for that wider outcomes, such as, say, protection of health or responding to climate change. And I think we will see that when there have been attempts to address very directly with IP, either they've been brought about or what I've been doing, people have been trying to argue for this, there's been a real challenge from the IP and data world, sometimes in courts, sometimes in policy and in debate. And I think this is very intellectually interesting, I hope you agree, but I think it also has a real world impact on what's often termed wicked problems. Most really important societal problems involve many, many regulatory and legal strands. And that's a bit scary. And I suppose what I seem to have taken on in my research focus is to work at how one can contribute to that. So I think I'm trying to look towards how we can bring about an intertwined approach. Now, that's clearly a big question. Is there actually one approach which one can take, certainly substantively in terms of overall value? And is there benefit in having one structural approach? What we'll actually see, I think, there have been some very different structural approaches which have been adopted. And this is something I've been starting to wrestle with for the last few years, which actually I've ended up probably accidentally being involved in a lot of the different regimes which have been set up. And I've become increasingly intrigued as to why they are structured in that way and what that means. And this is very, very much a work in progress. So I'm very much looking forward to the discussion and indeed the joy of coming back to research rather than being a dean. So thank you all. So yes, I think there are certainly opportunities for increased societal benefits from data and from technology. There can be new medicines, renewable technologies, drought-resistant adapted crops, for example, and wider access to information, which can come from and relate to the deep sea, soil manifestations and content, individuals' health experience, which might be of the wider interest. And I think those outputs can kick into wider goals such as health, environmental sustainability, and wider future research. And perhaps there might be, wherever one starts, an ultimate goal of sharing knowledge for the benefit of all and stewarding the resources which we have. But there might be some extremely different paths towards that. I think we see a deep intersection with patent, copyright, database, information control regimes, which at least as a starting point, I think, are much more privately focused. And arguably these are the good things without which there is no incentive to develop, say, the medicines. I think there's some increasingly interesting intersections I've been to explore with some philosophers. When you realize that different regimes are exploring the same thing from different angles. The control of raw data, which I've always been a little bit obsessed about, that, you know, there is a rugby pitch outside my office, who controls that fact? As against, is any information actually raw? Is anything always distilled by the reader? And can we balance a sharing-based approach to health with the patent system and its alleged incentive benefits? And to drill into that a little bit more, if we view that complex relationship, firstly from the IP perspective, I think we can see, happy to discuss, but very broadly, medicines, climate change related to response technologies, they certainly can all be subject to IP and information control, even if one might wish to fight around the borders or indeed reject that as a fundamental premise. There's probably an argument that these things have been brought about by IP and information control regimes. They're certainly the very standard arguments, the reward incentive, authorial reward as well. Also, of course, strong arguments, well, no, this would have happened anyway, certainly in relation to data and software related developments, and certainly from the individual science perspective, yes, the scientists would have wanted to make that medicine anyway. That is not based on private control. And maybe our incentive systems for now are based on patent, the funding mechanisms are based on patent, but again, there's clearly a lot of work going on in there. Prizes is just one example, exploring how we could develop them differently. So we have that whole debate, are IP rights a virtuous circle, even if it's quite a long running circle, or are they a block, at least in the short term? And building on that, the power which comes from information and data can certainly in the short term, I think, be extremely negative. One cannot use very broadly without consent or a different exception or relevant basis depending on the regime. And that gives the power holder a tremendous amount of power, which can block the results of the innovation and creativity. And this power can very much clash with other goals. And this has been extremely well explored for a long time from the IP side. Henning Gross-Ruscan, James Boyle are just two very well-known examples. We are seeing, I think, an increasingly willingness to explore this at national court level, which is an issue I've really focused on a lot in my work so far, being a former private practice litigator. I think it's been fascinating to see both in the data space, for example, Palantir, in the growing and exciting number of human rights and climate change pieces of litigation, for example, and just every so often around the world, we're seeing a court refusing, or certainly saying that, acknowledging clearly that it can refuse to grant an injunction in a patent or a copyright case. So the battle is there, the battle is going on in scholarship, a tiny bit in policy work, and definitely in the courts, but where perhaps might it actually be taking us? Before we look at that, I think interesting to explore this relationship between data, technology and societal benefits from another view, looking at the non-IP and data space. Now, there's a tremendous amount of work going on through the World Health Organization, national energy policies, through loads of other international treaties who are not focused on data, such as human rights. We have funder policy, Wellcome, NERC are some examples, and we have a real focus in legislation, in treaties, and minor progress, I would suggest, from Sharm el-Sheikh at COP27 regarding reducing emissions and the place of technology transfer in relation to that. These, I think, have some really important differences and B concerns in comparison with the IP space. Firstly, all of these have a public focus. For example, the UK and Scottish Climate Change Acts. If one is concerned about that, if the obligation holder is not meeting the obligations, then there will be judicial review. Now, that can be very effective, but it's not the same as share your patent wind farm owner. So it's such a very different type of regime from what we have. There are some very strong assumptions, which I understand up to a point, but the more time I've spent over the years in reading policy documents and treaties, I've just got more and more annoyed about that IP and information control are an effective, indeed the only way of encouraging innovation. It's just not true. And when I'm lazy, I scan a document and I just look for intellectual property and it's never there, but lots of talk about innovation or technology transfer. Or there's an absolute assumption that, well, IP rights are a good thing, and that's how we're going to get more innovation through more IP rights. What we've also been starting to see, which I think is really fascinating from the work of Cohen, very much on that border between IP and other spaces, and the work from Leonelli, which is coming much more from that philosophical regulatory side, the strong public and private conflicts which arise within this, but perhaps not, I would say, enough willingness to engage directly with them. And this, I think, drills us down to the really differing priorities that we are seeing, which is not quite the same. It's certainly linked with the fact of you want your patent, you want your medicine type of fight, but it's incredibly fundamentally deep. I think I've seen certainly some discussions, and when we read some of the literature, there's the view that, well, in essence, this is all about sharing. The most important thing is the word to sharing to save lives, which is such a totally different narrative, which one sees in the IP and data space. And I've been reading and learning a lot about interpretative communities, and some scholars are there in the screen I'm starting to do battle with, but the real power of interpretive community. And when I first came to the academy, and I've been a practicing lawyer, I remember being fascinated by the work, particularly of Drahosh and Brownsword, really exploring the fact that, you know the rules of the game in your box, essentially, that's your community, and you can't really go beyond it. And I think we're still suffering quite a lot from that. A middle ground, perhaps, is the increasing work by particularly Helfer, Young, and Frankel, looking at regime shifting, mandate collision. Is it of value, for example, to have the climate change treaties, but we don't have climate change specifically engaged within TRIPS. We don't have requirements on technology transfer and IP, specifically in the Paris and related agreements. We have some obligations in TRIPS. Is it good that things live in their own space where are considered the most important thing, or are they just being pushed off into a sideline? And how do we actually deal with mandate collisions? And as we'll see, I don't think we actually deal entirely well with mandate collisions. And what I think I'm really obsessed with and looking to dig into more and welcome discussion on is, are these, for example, the Paris Agreement, is that a careful balance between the need for private incentive to engage in intellectual property with the benefit and technology transfer, which can arise once those technologies are developed to respond in one way to climate change? Is it they were too terrified to engage with IP rights, so they didn't want to engage more broadly? Or is it they just kind of didn't want to go there because they didn't really know enough, because they didn't really think it was that important, other than a few valuable exceptions who were arguing for the engagement with that? And I think that's really important, because balances have to be struck. But where are these balances struck knowingly, or is this a real fear of engaging with the IP and data regimes because they do give power and they can be seen as so very different from, say, the climate or health mandates? Now, maybe, just maybe, it's been a long week. I'm a bit tired. There's a lot more hope out there. There is that a little bit, definitely. Just a few examples coming up on the coming slides. Digital Strategy for Scotland 21 talks about a vision of an ethical digital nation, talks about going beyond protection of individual data, engaging fully with all sectors, for example. The UK's geospatial strategy 20 to 25, technology alone is not enough. We need a collective effort. We need to learn from other countries, and we need to connect leadership, governance, policies. UK needs to create the right marketing conditions and incentives for innovation, quite market focused, and then perhaps not surprisingly, while safeguarding national security, intellectual property, and individual privacy. And maybe it's age. I mean, that's a fine statement, but I get increasingly nervous. Just like, no, that's just a cop-out. That's saying, okay, so actually IP is always going to win. It's not what it says, it's not what it needs to mean, but I think often we do see that. But we are also seeing within the geospatial strategy, and many people in the call in Scotland are involved in this, a clear commitment to ethics and privacy guidelines, and there's been some work with the Turing Institute and Ada Lovelace. Up in Scotland, we have the Just Transition Commission. It's talking about the need to make Scotland a good place to do business, need for a deal between the public and the private sector, that the public sector can be a very important place, conditions and seed funding for low carbon technologies, also a space for the private sector, and we should really embed transition in all the funding structures which we are making. And in UK Net Zero 21, Bring Back Zero, Build Back Greener, looking to a systems approach, dynamic approach, considering public reactions to a policy, considering effects in one sector on another, and the wider impact across the economy and the environment. So this doesn't seem too siloed. It does seem at least there is an awareness of the approaches elsewhere. And in UK decommissioning, so responses to certainly those bits of oil infrastructure which can no longer be used. They've noted that a real problem for the sector, for the industry who are involved in this, is they don't know when the projects are coming up. And this is quite inefficient for them to do this. They cannot plan their work. Now we'll have differing views on whether we think that should be a priority or not. But it's interesting to see how the sector has really responded to this. They've set up a task force co-chaired by the North Sea Transition Authority, which we'll see used to be the Oil and Gas Authority. But big operators, BP, Enquist, Spirit Energy, have agreed to the release of their field-specific decommissioning information. And they're happy to share this. This hasn't been forced. They have agreed to share this so that everyone can help and everyone can know what is going on. So, and perhaps some of us involved in the wider software space, the common space, this is not surprising, but it's perhaps a bit less usual in the commercial sector. Also interesting to see UK Environmental Act 2021. This has obviously been trailed for a long time, but we now do have the fact that environmental principles are supposed to inform all government policy making. And a draft policy statement was released earlier this year. And we do have this very clear direction that all ministers, any policy, are to have due regard to various environmental principles, including an integrated approach and the precautionary approach. Now, due regard, of course, does not mean follow. And the guidance which has been provided makes this extremely clear. But it'll be interesting again to see where this goes. And I do find this quite exciting as a possibility for this more intertwined approach to come about. And finally, some of us will be familiar with this and this will be newer. I always like to mention the Marrakesh Treaty. So this came through WIPO, but is probably the first IP treaty which really makes a direct reference to human rights substantively and also creates real obligations that there should be exceptions to IP rights to deal with. Admittedly, a fairly narrow set of circumstances, but it does create that obligation, and that is often called the miracle. But hey, we could all have gone home after 20 minutes, but no, I still think there are some real problems here. As I mentioned, we have the UK and Scotland Climate Change Acts. They talk a lot about technology, a lot about transfer. They don't talk about IP. And this, this is what I do, what I obsess about, the fact that how can you say the answers lie in technology without engaging with IP rights, and the fact that IP rights give you the right to say no. For a short time, perhaps, possibly for the best of intentions, but this is just an absolute fact, and there's no engagement with this. And my previous book spent a lot of time exploring this. We see the same in the Paris Agreement. We see the same in the UK's 6th carbon budget, going on to 37. It's a bit scary. We see it in the Scotland 2021 Path to Net Zero to 2032 document. Perhaps a little bit more sympathy, because as we all know, this actually cannot engage with IP or not in a directed manner because it is not devolved, but still one would like to see that acknowledged. Within the UNFCCC, the CTTN, Climate Change Technology Network, part of the technology mechanism set up building it came about before Paris, but much more entrenched since then. It makes annual reports, it does a lot of work. The picture on the screen is me in my hometown of Glasgow at COP26. And I sat in the room as an observer when they were finalising the annual report. There was loads of brackets, there was loads of huddling, there was loads of great joy when they reached their agreement. They don't talk about IP at all. And I find that frustrating, but also I think very, very misconceived, because I think it's failing to engage with some really important problems. Not to say that the other work, technology needs assessment, for example, is not of value, but I think it's missing a real problem. And I had a little rant about that in my blog post on the screen. And I suppose what I also felt is worth noting, and this is going into an even wider area of work, even for me, but I think it's relevant here, the whole practical challenges of who can get into the room, who can argue what's happening, who can contribute to what is happening in negotiations. Now, Giles and Braithwaite, for example, from TRIPS did some excellent work on this, and Hafstine and Gervais have been continuing in that. But I think interesting that going with colleagues from the university who just said, well, we're observer, why can't we get in that room? Maybe realise how much I started to accept that fact, that one couldn't get in the room. But also that if you're not allowed in the room, perhaps those barriers are simply always going to be there. And maybe a couple of years ago, when the pandemic was at its height, I certainly had a moment of hope, if that's not too awful a word to use in the world in which we were living then, that maybe all this concern, these barriers between fields, these reluctance to share, that would pass, because this was something really awful, which really was affecting everyone. And there had been the reluctance to engage HIV/AIDS as one classic example in relation to SARS as well. We'd seen the US prepared to do compulsory licensing in relation to anthrax. Maybe it would be more like that. Maybe we'd see a more communal approach. And we saw a little bit of that with one of the WHO pools. But I certainly don't think it's happening. WHO pandemic treaty, which is obviously still happening. There is going to be, the next step of the meeting is coming up very shortly, but it's going really slowly. The IP waiver, well, we got one eventually, but I don't think it's nearly as much as it could have been. Colleagues who have written on screen, Tamseti McMahon, Ying Kang, Dutfield and McDonough did some valuable work leading the academic voice in arguing for this, and I was honoured to be one of the signatories to their work. But I think what they have actually come out of a waiver is really very, very little. And the work which from Amino and Kahumba from South Centre published very recently, but actually from before we had the waiver actually coming about, just I think is a very timely reminder saying the opposition to the waiver should be seen as a warning sign. And it also notes, which again puts this so much better than I could, the view that for some, IP is revered as it's believed to be based on pure meritocracy and creativity, and it perpetuates the understanding that IP is sacred and its regulation is seen as an affront to the authority of property. And I think that's what we see a lot. People might not put it in that way. They might even recognize that that's what's happening, and that's what I'm wanting to dig into. But I think we do see, whether you see it as fear or whether you see it as sacred, there's much less willingness to engage with IP and data control regimes, and a willingness to say, oh, well, health, yeah, it'll be solved eventually, which is just remarkable, I have to say. So, are we in a world where we have a lot of blocks? Or might we be able to move to a more collaborative, intertwined approach? Might we be moving there already? How might we do more? So I've got some paths, some thoughts, some possible outcomes, and again, this is very much up for discussion. So one path which I think could be done, and which I had the privilege to be a little bit involved in, is to creating a new regime. We've been quite rude about some regimes. Why don't we just try and create a new one? And an opportunity to do that has been in relation to marine biodiversity beyond national jurisdiction, when a PrepCom was developed from 2015. There was obviously work before that, and maybe, just maybe, there'll be a final meeting and agreement planned for February and March next year. So this is under the UN Convention on the Law of the Sea. In essence, it's the big bit of the sea beyond, if you're not in international law, those charty things we used to do in class. Beyond that, it doesn't belong to the UK or any other country. It's a deep sea. It's less regulated. It's not entirely unregulated. It's less regulated. And there's been now a recognition that maybe one should try to engage in that. A lot of that is from the conservation and sustainability perspective. But two key points which are very much in the mandate are access and benefit sharing regarding the results of work with marine genetic resources, and also capacity and technology transfer in relation to marine technology. There is a strong theme throughout this agreement, throughout this world about sharing and sustainability. These are environmental lawyers. This is not remotely surprising. I got involved in this work through my colleague Marcel Jaspers, who's a professor of marine biodiscovery, and he does, and I still think it's the best way of describing it, so I always apologize to him, but I still use it. He makes drugs from plankton. Now technology has moved on so much that you actually don't so much need the real drugs. You can zap the drugs like a supermarket scanner or a park run scanner, and you can turn that information into data, so much more sustainable, and the information goes around, and then we can still make drugs from plankton. So that's one possible great output. Also, one gets much more information about these new bits of plankton, which apparently are in the deep sea and they've never been found before. So this is very exciting for science, and it's very exciting for lots of opportunities which might come. And they're going to put them in databases and they're going to share them with everyone. And I'm afraid I say, well, what if Apple end up controlling the database? And they go, huh? Where did she come from? But I think there's a really important point. Drugs are made from plankton. Who's going, how does this time with the patent regime? We're trying to get into important databases. Who might end up controlling those? And how do we engage again in technology transfer without engagement with IP? And what I've really felt in my discussions, and this has been an incredibly welcoming community to me, and they've been very polite when I'm probably quite rude about some of the work that they're doing. But there's an absolute assumption that if they can agree that there should be access and benefit sharing as to how this is going to be done, which raises lots and lots and lots of problems, that IP will not stop them. And I'm just like, well, it really can. And there's a lot of engagement in this space about disclosure of origin. It's clearly a well-established issue, but the basic fact that maybe there might be patents too early on in the supply chain, patent owner might not wish to permit, or a country might not have research exemptions, for example, and these databases, which are presently largely publicly funded where they exist, might end up in the private sector. My impression is, first of all, a real lack of awareness of this, which is not surprising because these are environmental lawyers. But then I think a real fear of getting involved in this, and partly was, many people said, well, that's what happens at WIPO and the WTO. And I just said, well, no, it's not. And they look quite horrified because this is what they kind of been told by their briefers. Now, more is now happening at WIPO, just very recently. It has started to move into the deep sea space, but that was very recent. And of course, the genetic resources discussion at WIPO have been ongoing for a very long time. And some of it also is that these people simply don't know about this and they want to get this agreement over the line. And when does trying to be helpful, trying to ensure that the agreement is more sustainable, trying to ensure the agreement cannot be knocked down. I spoke to some US students about this at Georgetown, and I said, it's about avoiding the lorry. And then a student bravely put her hand up and said, I don't know what a lorry is, I'm sorry. So hopefully everyone knows, big truck. But there's lovely agreement about sharing, and the IP owners just say, well, we're not going to share. And my view is that it's helpful to at least explore how we can engage with that in the agreement. Other view, of course, is, well, no, we should wait, we should deal with it in a different manner, or we should leave it to COP. But my instinct is that we should at least explore that a little bit more, and we should try and do a bit more silo crossing. And part of that, I'm not going to play it to you, but do follow up afterwards, is when we've engaged some really exciting public engagement through the Song of the Ocean. And recently we translated that through our Law, Chemistry and Philosophy project through lots of different European coastal languages. So those translations are there as well. So we could create a new regime, but that's going slowly and that has its own challenges. The other one is to work within an existing regime or a newer regime, and to change the approaches to some existing rights. And this goes very close to home because the National Data Repository mentioned at the bottom screen is, I can see it from a window. Initially, this was the Oil and Gas Authority, now the North Sea Transition Authority. And this all comes out, it's now regulated under the Petroleum Act, but it draws from a review, the Wood Review, called Maximising Economic Recovery, because of that view, there was a feeling that we had to make more money from oil. Now, this obviously is a controversial view for many, but this is where this had absolutely started. And so the principal objective of the regime, as updated from that, was maximising economic recovery. This has in fact now been changed. There's a big focus as well on stewardship within that. But within this regime, which has been set up, It's a bit like Dallas, or I've just discovered State of Happiness. Don't know if anyone's ever seen this, but you're given a license to drill in your plot in the middle of the North Sea. And if you find oil, you get it, basically, subject to paying a lot of tax. But if you don't meet the requirements of your license to drill, your license can be removed. So this is a really, really effective sanction. And from 2018, there have been 2 new information control regimes set up, which I think are really fascinating. Now, much, much more quickly than had ever been so in the past. License holders, they have to retain information. So broadly saying, yeah, this is how much oil is in my patch, even though I didn't necessarily drill it up yet. And then a map can be built of where all the oil deposits are across the North Sea. And as well as keeping it, then it has to be disclosed. You have to give it in to the National Repository, and then it will be shared by the regulator. This happens to be about oil, which might not be seen as in the public interest. However, many people think it is, and they talked about it as being a national asset. And there's that link there to the North Sea Transition Authority, as recommended by the Wood Review. We're trying to make information and samples publicly available as soon as possible. They have restricted the confidentiality regimes. Now, I think this is really, really fascinating, because these are big companies who have a lot of power, and they have followed a big consultation which said, look, we're all going to share a bit more. I'm not sure we can imagine that happening in pharma. This happened in oil, in a very competitive industry. The OGA, which it was then, it led a consultation in 2018, which led to these bits of regulation. It engaged very directly with trade secrets, less so with IP, which I think is surprising and something I will come on to, but engaged very directly with trade secrets. And the view was, this is a national asset, finding where the oil is. And the industry was kind of quite happy-ish, maybe, with this, maybe because they all want the data. They know that the world will return, they'll be applying for a license in that spot in due course. So maybe it's quite good for everyone to know where the data is. So the industry is not resisting. There are also some quite hidden balances when I dug into this, registered agreements, database exceptions, that maybe it's actually not quite as overriding trade secrets and certainly IP rights as one might have thought it is. But I think this is still quite a remarkable, the only clearest instances I'm aware of someone saying, you IP rights, we don't care. We didn't see that in COVID. And that might have been where we thought we did, but we haven't seen that yet. Or maybe there is a fight looming. If one looks across to Canada, Canada had legislation like this a long time before the UK did. One can see very clearly, in contrast to the UK path, consultations, travaux preparatoires, saying, yeah, we want this information to be available to everyone, and we don't care if it's a subject of any other rights. And then in 2017, we have a copyright case brought by a business which is focused on data control. That's how it makes its money. And so someone used the information which had been obtained from the oil central resource, they were sued for copyright infringement. And the court said, no, it's not copyright infringement because of the regime which has been set up in the oil legislation, which I think was, in one view, very standard statutory interpretation, but absolutely fascinating to see a court perhaps brave enough, or maybe it wasn't brave, maybe this was entirely standard. Maybe it was back to those to the policymakers in 1985 to say that other things were more important than IP, which again, we don't always see. However, many will be very familiar, some of you much more familiar than I am, with investor-state dispute settlement possibilities. Now, in some ways, I quite like this possibility because I think it enables the real fight to take place. And the real fight is often between the IP owner and the state rather than a state-state fight. But equally, it's totally objectionable that a large IP owner can challenge what a state has been doing, say, in relation to health, or here in relation to energy policy. And here we have an action has been made under NAFTA against Canada, challenging what they have done within their laws and within their court decisions. So I think that will be really fascinating to where that goes, and a really important reminder, perhaps, that even if you think that the oil regulator is the biggest person in the room, if one wants to reduce it to basic power, we're actually seeing another path coming in through ISDS. So it'll be another fight. Another path might be to set up a special panel. I have been involved in this. In Scotland, we had a new panel set up to grant access to data for reuse in health and social care. This might be someone who lives in a particular area who has a particular illness. If there's lots of people who have that, that might be really important information for health researchers. This was set up, this really draws together a lot of different regimes. So I find this quite fascinating, reference to trade secrets, references to professional confidentiality from doctors, but also big data protection powers. And this body has been set up with delegated powers from the relevant obligation holders. You apply, there's a long form, there's lots of resources, lots of training, and it's now interlinked with wider health, social and digital strategy work, which Angela Daly, I don't know if she's in the con, she's got a leading role in respect of some of that. So it's sort of a panel of the great and the good, well, apart from me, but you go in and you say to this panel, look, I need this information. I know some people control it, and I'm going to do this great stuff with it. I'm going to cure cancer with it. Please, will you give me the data? And then we think about, well, are you asking for too much data? What are your plans? All of this is publicly available on the site, which I'll show shortly. Are you engaging with the public, for example? And it's very clearly talking about balancing two conflicting public interests, which I think is really interesting. The social need for processing of the data, but and people might think, well, it should be kept secret, I don't want it shared, but equally a tangible benefit from society if, say, one could cure cancer. So this has been a really good way, a very different way from the two paths we've seen so far about how to balance different interests. I think questions which, again, are freely available on the site is being noticed. You have to declare a commercial involvement if anyone is involved in your project, if anyone could be making money from it. And I think that is an area which is definitely an area where we'll see further activity. And that's the website there. And then the fourth approach, conscious of time, is what I've called an accidental UK hybrid in relation to soil and environmental data. And there's lots of different frameworks. Guido mentioned I'm involved in the NERC CDE work. So some of the bodies have open licenses, some are making money, some requirements want you to share, some want you to share, but you have to pay money. Everyone is very much learning. I read a workshop in this at our conference in July, and there's going to be further activity on that. Which is, I think, also interesting, speaking to scientists who are working in this space, is often say, yeah, there's all this stuff, but actually we go to the UNESCO open source thing. So a real reminder of reality of what people do as against the regulatory framework can differ. So we have the UK Geospatial Commission, which I mentioned before. A lot of people are involved in this, but not everyone. I've spoken to some people who are very worried about rivers and flooding, and their work isn't covered by what's going on in the Geospatial Commission. And that's important because they do have a data exploration license, allowing some freely accessing information for research, development and innovation. They do have a master map, which you can see, and they're very much embracing the FAIR, findable, accessible, interoperable, usual approaches. So, and they're seeking a system approach. They're really trying to act within the things that they do, which is not everyone. We also have in Scotland, if you do funding applications I do, they say, what's the infrastructure box? And I don't understand it. If you're a scientist, a desk scientist, or a field scientist, one of the things you might want is access to the Scotland's National Repository of Soil. And that's something that scientists go into, and they take that away and they use that in their work. Now, these surveys are actually the copyright of the John Hutton Institute, which is also in Aberdeen. But there is a very open license framework which is available, and it can be done for commercial and non-commercial purposes, and it's very similar to the UK Open Government License. We'll contrast that with the position in England. This is not the day for minor rivalry, except maybe it kind of always is. So in the 1980s, there was a privatisation, in essence, in England of soil data. So things went to Cranfield, and they do, some information is freely available, but they are regulated in an entirely different manner. They can grant licenses for the work, but this is how they make their money. So it's been structured in a totally different manner by what we are seeing in Scotland. And I think that's just really, really fascinating how we got there, how it actually works. And from Botswana, we can see debate starting. Why isn't the National Soil Map open data? And that's what we're doing at the CD. So yeah, I'm looking at what's the path. Can one draw together consistency, or is that not the right question? Is variety actually helpful, but can we still learn more from what is happening in terms of different goals and different structures and different balances which are coming about? And indeed, are those balances actually working? So possible breadcrumbs, can we go to plot a new path? How can we embed or prevent holistic approach? What do we want? Brownsore's most recent work talks about a wall, which is like a merger. I love a merger, but you see there's a board and there's pictures, and he talks about what gets on the wall, and what they do with the wall, and I'm interested in looking behind the wall. What gets on that board? And I think there's so many assumptions that we need to unpick a little bit more, and who's allowed in that room, both ideologically and personally. And some of this, I think, can preempt risk, because if you're not widely aware, you could have a lorry running at you from IP rights, or you might not be aware of the ISDS potential challenge. So I'm hoping to do some qualitative work, speaking with colleagues, very early stages, but people have indicated that they may be willing to speak to me about how these structures were created. What was on the list? What did they think about? Was it always about money? Was it always about sharing? Did they think about the IP rights? Did they not? And how it actually seems to be working. And then this is where I think I'm trying to go. Building on some different pieces of work we're seeing, Julia Black's work talking about moving beyond I think we should move beyond governance of individual systems. She talks about a need for looking by the eyes of those you're trying to govern. And I think that's quite right, but are there a few silos in there as well? Should we be looking at a more collective, a more sharing, sustainable based approach? Should we be less worried about certainty and evidence? And what people think of as important for certainty and evidence varies if you're speaking to a lawyer or a geologist. But I think a more precautionary based approach, a more willingness to say it doesn't have to be about the IP right or the license that you can touch. We should have a much more open type of value structure, I think might really help in trying to work out how we do balance regimes sensibly. And apparently, in the book proposal I sent out, I'm going to develop a new theoretical approach and practical path. So we'll see. And on that note, I will leave it there. I hope I haven't overrun too much, and I really look forward to our discussion. Thanks very much indeed.
Thank you. Thank you so much. Abbe, that was so fascinating. Loved it. So many thoughts. But we have a discussant, so I'm gonna ask Professor NcCube to say a couple of words on this presentation. Thank you.
Thank you very much. I smiled a bit when you said a couple of words, because it was so interesting that if you let me, I would probably run away and take away all the discussion time. So I'm really going to try and rein myself in. It was a brilliant presentation, Abbe, as always. I'm very happy to see you again, albeit virtually, and hopefully we will be able to see each other again in person in the near future. So what I thought I would do with the 5 minutes or so to lead into the discussion would be perhaps to give my own take or my own understanding of the takeaways from Professor Brown's paper. It's often useful for a scholar to hear how other people actually perceived what they were saying. So I'm going to say some of it back, just so you can hear how we are perceiving it. And then because of time, I'm only going to pose 2 questions, I think, and then let everybody else have their say. So Professor Brown has outlined a fascinating project that is going to look at regulatory regimes. She's going to be talking about IP and what she calls information control, which I found like a very interesting level as well, because one would start to think about what kinds of things you'd be thinking about going into information control. And for me, obviously, I'd be thinking privacy, those kinds of things, right? So that was interesting. Data governance, perhaps. And really, for me, the wicked problem that you seem to be engaging with is how we make sense of how these core regimes of IP and information control actually interface with other regimes that are out there and that are equally important. And so you cited human rights. I might also add to that list kind of developmental fields, things like climate change, which you did in fact mention. And you painted this picture that the relationship between these regimes is somewhat at a distance. So when you were speaking, I was writing down words, and the words and phrases I wrote were distance, fear, no-go areas, because the sense that you are getting, and that I also share, is that in various contexts, many policymakers or regulators don't actually want to engage with IP and information control because, you know, somehow they have the sacred quality or whatever it is, which is quite nebulous to get to grips with. But nonetheless, having laid that background, you then say to us, it actually doesn't make sense why there's this distance, why there's this fear, why there are these no-go areas, because each of these regimes, at the heart of them, they're seeking to give us some kind of societal benefit. And one would think that they would work together, but not so, right, you say, which is interesting, surprising, perhaps even disappointing. You then give us some examples of where this distance is clear, where we've seen it, where the connections have failed to be made, for example, the IP TRIPS waiver, for instance. But then you also gave us some hope, right? You gave us some insight into some miracles where it has worked. And you spoke particularly about the Marrakesh Treaty. I mean, you had a long list, but my eyes lighted on Marrakesh because I'm an IP scholar, and so that's what kind of speaks to me. And then I wanted to just say two things about that. You know, those examples of hope that you gave us, particularly Marrakesh, has been described as a miracle, which to me is telling of itself. The miracle we are saying is that we don't find the regimes speaking to each other. So to us, it's miraculous that an IP treaty would actually reference expressly the UN Declaration of Human Rights, or would actually even speak about the Convention on the Rights of Persons with Disabilities. That to us is miraculous, which it should not be. And I think that the aim of your work is to say, let's make these miracles ordinary. Let's make them the everyday thing. Why are they miracles and not what we normally do? And so, you know, you gave us examples of how this may happen, and you gave us 4. You've just gone through them. And so in the interest of time, I probably shouldn't list them again. And then you gave us really insightful examples of those 4 models in play, in oil and gas, in soil. And so I thought that all of those were really insightful. And what really struck me is that, particularly with the oil and gas example, you're speaking about a particularly powerful industry, which is what we encounter in other areas, pharma, for example, as you rightly said. And so what's interesting is how come there was this breakthrough in oil and gas, which we're not actually achieving in other industries. So a very interesting, I think, area that you're wanting to dig up and to dig into, rather. I think you've dug it up beautifully. And now you want to dig in to find out how it works like that and how we should change it. And so, having summarized it like that, and I've chopped and left things out, but I hope I haven't done too much violence to your project, Abbe. The 2 questions that I wanted to pose were these. So the examples that you gave us, UK, Scotland, and then the one international treaty, the marine one, that's quite interesting to look at. But I did notice that you gave us like national and then international, but there wasn't like a regional one, like maybe from the EU, or maybe in my context right now, because we're looking at the African Continental Free Trade Area. I was actually thinking about that and thinking, what would it look like in a region, in an economic region? So maybe some thoughts on that. And then the second question would be just to light on the research that you're going to start now, the empirical research, the qualitative interviews you're going to be doing. So I thought if our sense and your sense is that there's distance, there's fear, there are no-go areas, you're going to be talking to people who've kind of bridged this, right? And ask them how they make the miracles happen, or how the accidental hybrids came about. I wonder if they would be able to actually articulate views on IP and information sharing in the language that we normally use in this field. And I wondered how you were going to unearth that, because maybe if you just ask the question bluntly, did you consider IP, that might not spark off anything, because I don't know. So I was just wanting to get a sense of how you might engage with that. But I have been way too long. It's just the result of my being so fascinated. And I'll stop here, and maybe we can collect some other questions, and hopefully you'll engage with them all. Thank you.
Thank you. Abbe, what do you prefer to get other questions, or do you prefer to answer now?
Well, why don't we open the floor and then I can pick things up all together, if that's all right, Karen.